straight into the issues right now as the fate of the Chief Justice Gertrude Arba Esaba Saki Tokonom now hangs in a balance following the decision by President John Dramani Mahama to suspend her from office. The Chief Justice's interdiction follows the establishment of a prima facie case in 3 petitions seeking the removal of Madam Tokonom and the subsequent setting up of a committee to inquire into the said petitions. We've got in studio Dennis Paperu, Adam Esquire, and Dennis, look, we've been on this part for quite a while now. The first time this particular matter became public as to the 3 petitions against the Chief Justice, when the statement was issued by Felix Kwakye-Ofosu giving us that particular indication, you had mentioned as part of Article 146 a number of options and how the steps will play out as from then till now. It's been almost a month now that this particular issue has been playing out since that first announcement, clearly indicating Article 146(10)(a). This is what has been activated now, is it not?
Precisely so. And Alfred, I mean, even last week we had reason to clarify some things that needed to be done before a possible suspension, because the conversation out there already was to the effect that there was a suspension. And just to set the record straight, at the time, we did indicate that per the provisions of Article 146(10), certain things needed to have been done before any suspension could have been activated. So we were clear in our minds that we hadn't gotten there yet. Because, of course, when you look at the construction of Article 146(10), it talks about the fact that there has to be in place a committee, and even before that committee will be set up, it meant that the President, in consultation with the Council of State, ought to have found a prima facie case against her. As at the time, we had not got any indication as to the confirmation of that. Talk less of the setting up of the committee and then a subsequent submission. But as we speak now, all those things have come to pass. It is now clear that a prima facie case has been found against the Chief Justice. A committee has been set. The petition has been referred to the committee the petitions have been referred to the committee to look into same, and then she has subsequently been suspended as being the Chief Justice of the Republic of Ghana, Alfred.
And as per the details of 146(10), as you did indicate earlier with that education that we got from you, the details of the prima facie so established, we will have to get to know, is it not? It has to be made public.
Well, so the provision is that, the law regarding all this is that all these things are supposed to be in camera. Yes, we will be told as and when major milestones are made. For instance, the referral of the petition that we were told, when the petitions were referred to the Chief Justice for her input or response, whichever way you want to put it, we were also informed. Now that she's also been suspended and the fact that a committee has been put together in consonance with Article 146, we have also been informed. Because mind you, the Chief Justice is not only the leader of the Supreme Court, she's also the administrative head of the judiciary. And to that extent, she is the leader of the judicial service. So if the head of the judicial service is suspended, we all as public do engage with the judicial service, so we have to know about that particular occurrence. So yes, we have to know, but as to the content of the petition, the responses, and all that constitute the proceedings of this particular engagement, all has to be in camera, at least. That's what the law says, to protect the sanctity of it. And that's why, when you look at a letter that was written from the presidency to the Chief Justice, the presidency was quite worried that some portions of the petitions were in the public, and they had indicated that they had to mark some of all the pages of that of the documents that were sent to the Chief Justice, just to ensure the sanctity of the process and that they do not get leaked. But this is a new world altogether. As much as hard as they try to keep the things in place, some snippets of information still keep slipping out, which are purported to be excerpts of the petition. Because as the law says, we are not allowed to get into the details of the petition. In fact, we are deemed not to even know what the content of the petition is. And that's how come you do not see some of those communications coming out of. If not, you would have seen the presidency quote at length what the exact allegations are against the Chief Justice and what possibly her responses are and all that. But we are not seeing that because of what the law says when it comes to such proceedings, Alfred.
But let's get into the composition of this committee that has been now established as per the dictates of Article 146 of the 1992 Constitution. Who are on this committee and exactly what are the portfolios of these persons?
Well, so As the law requires under Article 1466, it requires that the composition of this committee should be a 5-member committee, 2 of whom should be justices of the Supreme Court, then some other 3 persons who should not be members of the Council of State, they should not be lawyers. So as we have it, the statement from the presidency did indicate that this committee now is being chaired by Justice Gabriel Scott Palmer, who is a justice of the Supreme Court. The second person who is a member of this is Justice Samuel Kwame Adibu Eseidu, Justice of the Supreme Court. We have Daniel Yao Domelevu, who is the former Auditor General of the Republic of Ghana. We have Major Flora Banwarinu Danlugu, who is a member of the Ghana Armed Forces. We have Professor James Sefa Jifa, who is an associate professor at the University of Ghana. This is a 5-member committee that has been composed to look into this particular matter, Alfred.
I see. And what exactly, and as per the details of 146, will be the mandate and responsibility of this committee?
Well, so it simply states that this committee is supposed to make inquiry into the petition. Now that a prima facie case has been made, it simply means that there is something in the petitions that the Chief Justice has to respond to, or there's something that links her to the petitions or allegations raised in the petitions for which she must answer. So essentially what this committee is supposed to do is to look into the merit of that and then make recommendations to the president as to what next to do. That recommendation, we understand by law, the president is bound by same. However, while this process is ongoing, then the president has the opportunity to trigger Article 146.10, which we spoke at length about, which has to do with the suspension, which the president has actually exercised by way of doing so. However, Alfred, it's also important to note that 146.11 is also another provision that we need to pay attention to, because that also allows the president to revoke this suspension at any time. So it essentially means that even though the suspension has been done already now, any moment between now till the end of the proceedings, if the president deems it fit, he can revoke that suspension as well.
In revoking it, that would be obviously not in oblivion. It has to be predicated on something, isn't it?
Well, so it doesn't specify exactly what it should be predicated on. As long as there's a suspension, it also gives the president the opportunity to revoke if he deems it fit. So these largely are discretionary matters within the purview of the president, and if he wants to exercise same, just as he has exercised the power to suspend, he also has that power to exercise if he wants to revoke that particular suspension.
I recall that when this injunction cases against this entire process was called again sometime last week, there has been a second adjournment. But I recall after that hearing that led to the adjournment last week, the former or immediate past Attorney General Godfrey Yeboah was making the point forcefully that in his view, the entire process should have been halted until the determination of the injunction cases against the process. The Attorney General, the learned Attorney General, Dominic Ayene, held a different view, that the president is only undertaking a constitutional duty. I mean, with this development right now, what becomes of those 2 petitions running as we speak at the Supreme Court?
Well, so as the practice would be, the parties would still have to appear before the court. Those are matters that the court itself would determine as to whether they would want to take a move to suspend the processes that are already in progress, or the processes that are already running. That is, whether to suspend or to injunct the president from carrying through what's already in motion, or to allow the president to go through with it. I mean, the former Attorney General is lawyer for the plaintiff and applicants in the matter of the injunction process. So you can understand where he is coming from, because they have gone to court essentially to stop the process and to hold the process. So, I mean, it is convenient for them to make an argument to say that ordinarily the process should be halted. The Attorney General on the other side is opposed to that. So it's also okay for them to argue that no, the president is performing an executive function. And I mean, truthfully, the courts are hesitant when it comes to injuncting presidents when they are performing their duties. So he made the argument clearly that no, for him, he does not think that it is a good argument to say that the president should stop whatever process is ongoing by virtue of just filing an injunction application. But also think about it, just as a layman, that if by virtue of filing an injunction application should stop the president, you can imagine how many people will go to court just to file injunction applications pending their hearing, meaning that government cannot run. I mean, but all those are things that will come to play for parties to make their arguments and also to aid the court in coming to a conclusion whether or not to grant such an application or not. But of course, there's also a substantive matter to be heard as to exactly whether or not the president is obliged or is an obligation in law to give a chief justice who has been petitioned against an opportunity to respond, so that such response will form part of the consultation that the president will have with the Council of State in coming to a prima facie case or not. And if so, how many days should such a thing be done? Should it be done before or after, and all those things? If the court deems it fit to go into the matter, they will certainly do so. If they, on the other side, do not think that it is a matter worth pursuing, they could just strike it out as moot, if depending on the circumstances. So we look forward to that 6th May hearing, if only it will come on.
Certainly so. And just for the uninitiated, there's a press statement that was issued moments ago, earlier this afternoon, by the Minister for Government Communications, Felix Kwakye-Ofosu. The Abresk Member of Parliament stated that in consultation with the Council of State, there has been a determination of a prima facie case in respect of the 3 petitions against the Chief Justice, Justice Sabatukonom. The minister a while ago spoke to my colleague Eric Maonek, but I'm going to put portions of this statement on the screen on Facebook right now, essentially detailing the reason why this suspension has been, as it were, acted upon by the president in activating Article 146(10)A of the 1992 Constitution of the Republic of Ghana. This is what Felix Kwakye-Ofosu said earlier.
I'm not able to disclose details of the process. As you yourself may know, there are strict rules of confidentiality. But I can tell you that such a conclusion has been reached, and it is on the basis of that the president has taken the step that I have just announced.
And so, amongst many other things, one question that's being asked is, this statement you issued is silent on who takes over now that the president has suspended the Chief Justice. What's the expectation of the president?
Well, the judiciary is a well-established institution in our country. They have their own administrative processes for getting someone to act in the stead of the Chief Justice in the event that she is temporarily unavailable. That is not a matter that the president determines. It is for the judiciary to make their own arrangements.
First ever of such a decision we've seen happen under any republic outside of the first ever president the country had when he removed the Chief Justice. What sort of processes went through this arrival at this decision? Because many are curious as to why we're seeing this happen for the first time and under John Mahama.
Well, the processes are clearly outlined in Article 146 of the 1992 Constitution. Indeed, you only have to read the statement I put out to appreciate the steps that have been taken. You recall that some weeks back, I informed the nation on behalf of the president that he has received petitions from 3 different quarters alleging various forms of wrongdoing against the Chief Justice and demanding her removal from office. Upon receipt of that, and in strict conformity with the dictates of the Constitution, President Mahama began a consultation process with the Council of State, which consultation process required that he, in consultation with the Council of State, determine whether there was any basis to proceed, i.e., determine whether there was prima facie warranting any further steps as prescribed by the Constitution. So you recall that he forwarded the petition to the Chief Justice in consultation with the Council of State and requested her to provide responses in order to enable an assessment as to whether or not some prima facie exists on the face of the petition. This was complied with by the Chief Justice, and the President continued the consultation process with the Council of State. And the outcome of that consultation was that prima facie has been determined in respect of all 3 petitions. This also then means that Article 146 of the Constitution must kick in, which then requires the president, in consultation once again with the Council of State, to set up a 5-member committee whose composition is contained in the statement I just issued. That membership of the committee is such that 2 of the members must be justices of the Supreme Court,
right?
One of whom will chair the committee, and 3 other individuals who are neither lawyers nor members of the Council of State. And so you find that the 3 others who have been named meet this criteria. They are not lawyers, they are also not members of the Council of State. Once that is done, the petitions will then have to be referred to the committee to inquire into as to whether or not there is a basis to remove the Chief Justice from office. Now, while the committee does its work, and once it has been set up, Article 146(10) of the Constitution empowers the President to suspend the Chief Justice for the duration of the work of the committee up until such time that they make recommendations to the President on what further step to take. So you find that everything the President has done has been grounded in the Constitution, Article 146, and its various provisions. So if you ask me about the process, this is exactly what has transpired since the tendency of these petitions.
All well and good, these processes you've outlined, but one criticism which is coming strongly from the quarters of the opposition NPP is that you're abusing these laid down processes in Article 146, and what we've seen happen up until this point is an attack on the country's judiciary.
Well, first of all, the NPP has come in for criticism for their unwarranted politicization of this particular issue. It is curious that it is a political party, the New Patriotic Party, that appears to be up in arms about this. Otherwise, every reasonable person understands exactly what is happening. That the President is required to act in specific ways once he receives this petition. In fact, before President Mahama took office, in the dying embers of the Akufo-Addo administration, a similar petition went to the President, and he took the same steps that the President has taken, except, of course, the determination of a prima facie. President Akufo-Addo also went into some consultation with the Council of State to determine whether there was prima facie in that petition. He, on that occasion, said there was no basis to proceed further. President Mahama, on this occasion, believes that in consultation with the Council of State, prima facie has been determined. So it is not clear why the NPP believes that when they are in power, their president can act in accordance with the Constitution. But when they leave power, another party that comes to power cannot act in accordance with the Constitution. So one has to question the sincerity that they bring to this whole discourse and question whether or not it is not politically motivated. Because quite frankly, they have not covered themselves in glory in this particular matter. They have needlessly politicized this and created an impression that the Chief Justice is one of them and she's been handed. And it is manifestly unfair to the Chief Justice what the MPP is doing. Their claims also do not hold merit because they cannot point to a single infraction on the part of the President in this whole process. And I'm not sure why they continue on the tangent that they are going. What has simply happened, and I must stress, that the President has not said that the Chief Justice is guilty of any offense. The President has only said that when he consulted with the Council of State and looked into the petitions and weighed them against the Chief Justice's responses, it became clear that there are further questions that need some answers. The platform to do that is spelled out clearly by the Constitution, and the President has followed that particular stipulation to ensure that the matter is determined conclusively, but it is determined by persons who are clothed with the mandate to do so, which is the committee that he has set up. So, again, I must express my surprise about the conduct of the New Patriotic Party in this instance. One can only infer political motives to what they are doing.
Just final question from me in relation to this 5 members we're seeing, senior most, second most, senior most at the Supreme Court, and then the membership. We see a security person, we see an auditor, a former auditor general as well, and then a person from academia. Is this leaning into the details captured in these petitions, which is forcing the president to toe the line in the individuals, the non-members from the Supreme Court, which were seen on this 5-member committee?
Well, the rules governing this process are pretty strict and stringent. One is not permitted to make any disclosures in respect of the details of the petition. It is only the President, the Council of States, the petitioners themselves, the Chief Justice, who natural justice demands is giving copies of the petitions, and the committee that has been set up who are seized with the petitions. No one else has a right or authority the details of this petition. So, regrettably, I'm unable to answer your question as to whether or not it is the nature of the petition that has necessitated the selection of the individuals who have been selected.
Right.
That if I were to go into the mind of the president, I believe that he thinks that these are the individuals who have what it takes to unravel the facts surrounding this petition, whether or not there is even any basis to remove the Chief Justice.
Then Felix, I appreciate that you could join us.
Well, so that's Felix Kwakye-Ofosu. There is the Minister in charge of Government Communications there talking to my colleague Eric Mayon-Egbeta, giving some details there, essentially making the point, and then is that the Chief Justice indeed responded to the petitions, but then again, looking at her responses, there's some further and better particulars needed. Reason why this committee has been established, and essentially she's been asked to in fact, she's been suspended while this committee does its work.
Precisely so, because it has also been and it has always been the Chief Justice's argument that, you know, she actually wrote to request to be given the petitions to respond to same, because her argument is that her responses, together with the content of the petition, will form the basis for the consultation between the President and the Council of State, on which they will come to a determination whether or not a prima facie case has been made. So, based on her responses, together with the content of the petitions, they've been able to come to that conclusion to make a determination of a prima facie case. But Alfred, what is obviously missing from the statement, for which many are asking, is the question of, now we have our Chief Justice suspended, who then is the Chief Justice of the Republic of Ghana as it stands now? Obviously, we don't have a Chief Justice as it stands now. However, somebody would step in to act as that Chief Justice. And
I heard Felix Kwakye-Ofosu talk about the fact that there's already a process that within the judiciary to have somebody act. It doesn't necessarily have to be President Mahama naming an acting Chief Justice, essentially.
Well, that's what he says. But when you look at the Constitution, there's actually a provision, or the Constitution contemplates a situation whereby a Chief Justice may be unavailable to perform his duties, and under such circumstances, it spells out clearly what should be done. So when you look at Article 1446 of the 1992 Constitution, it reads as follows. 6. Where the office of the Chief Justice is vacant, or where the Chief Justice is for any reason unable to perform the functions of his office. A. Until a person has been appointed to and has assumed functions of that office, or B. Until the person holding that office has resumed the functions of that office, as the case may be, those functions shall be performed by the most senior of the justices of the Supreme Court. So clearly, this is a provision that allows for the most senior person or the most senior justice of the Supreme Court to assume the functions of the judiciary in the absence of the Chief Justice, or under circumstances where the Chief Justice is unable to perform his or her functions, or as is the case that the Chief Justice has been suspended. And clearly, when you look at the current standing of the Supreme Court, the justices that we have and who comes in as the topmost person, you'd find that His Lordship Justice Paul Bafuboni, he's the senior most, followed by His Lordship Justice Gabriel Poamang, who is also on this committee, which is going to look into these petitions seeking the removal of the Chief Justice. Following Justice Poamang is Her Ladyship Justice Evel Lovelace Johnson. Following her is His Lordship Justice Isifu Imorotanko Amadu. And then we have Her Ladyship Justice Professor Henrietta Mensah Bonsu. We have His Lordship Justice Emmanuel Yoni Kolondi following. We have His Lordship Justice Samuel Kwame Esiedu following closely. And we also have His Lordship Justice George Kingsley Kumsin. Following him is Justice Ernest Yao Jehu. His Lordship Justice Henry A. Kofi. We also have His Lordship Justice Yao Dakwasari. And then finally, we have His Lordship Justice Richard Eji Frimpong being the youngest on the bench. So when you look at the standing of the Supreme Court justices, Bafuboni is the one who is the most senior after the Chief Justice herself. So even though no name has been given yet, we don't know whether it's going to come from the presidency, it's going to come from the judicial service. Like I did indicate from the beginning, the Chief Justice is also the head of the judicial service, and she belongs to that service. And I get the sense from what Felix is saying is the fact that the judicial service itself has its own way of announcing or naming whichever person is going to be the acting Chief Justice. But this is what the law provides under Article 1446 of the 1992 Constitution.
I say, well, Justice Bafuboni has been